This recent Supreme Court decision permitting reasonable mistakes by police in searches. So the case stems from this 2009 search in Surry County, that's in North Carolina. And here to talk about the case, what it means for officers and you if you were to be pulled over in the future, Corey Rosensteel from Rosensteel Fleischman. And this is a very interesting case here. Let's go over the basics. This driver was in Surry County, gets pulled over by an officer for not having a tail light, right? One of the tail lights was out. He thought the law was, the officer thought the law was you have to have two working taillights. That's not the case. But what happened afterwards, that's where it gets complicated. Take it up from there.
Well, so in North Carolina, we've got this old law that dates back probably about 100 years. And it only requires one tail lamp under the technical reading of the law. Well, the officer misconstrued that law. He thought that there were required two tail lights. Well, what ends up happening is this case first goes in front of a Surry County judge. That judge then gets appealed to the Court of Appeals, the North Carolina Court of Appeals, and the North Carolina Supreme Court. Eventually, the case goes in front of the Supreme Court of the United States of America. And the question is, if the officer was mistaken about the law,
which he was,
should we then suppress any of the evidence from his stop?
Because inside that car they found cocaine, correct? And he was busted for drug trafficking, correct?
That's right. It turned out not to just be a traffic stop about a taillight. It turned out to be a much bigger felony case about trafficking drugs. And so the question for the Supreme Court is, if this officer's mistake is reasonable, and they found that it was, that this was a relatively arcane law and difficult to interpret, then is that reasonable mistake of law acceptable for the officer to pull somebody over and for the courts to still use the evidence underneath it?
You get into this reasonable. It's such a broad word. You know, how do you define what exactly reasonable is? Isn't that kind of where the gray comes in here?
And that's one of the difficulties. Justice Sotomayor in the dissent raises that point, that reasonableness is a difficult standard, and especially when we apply it to law enforcement officers, because what's a reasonable mistake for a law enforcement officer to make about the law? And that's really going to be the question.
Yeah.
Well, the courts say that it's going to be a very narrow decision. They say the Supreme Court says that that's going to be something that's going to be rare. But of course, that's the issue. Where and when do you draw that line?
So again, this person had cocaine in the car. If this had not been allowed, if they would have said this is an unreasonable, just reverse the whole thing, the guy gets off?
That's probably the case in this situation. It's called the fruit of the poisonous tree doctrine. That's what you'll hear sometimes. And if it's an illegal stop, then at that point, the evidence that's gathered is now no longer admissible in court.
Yeah, even though let's pretend he was pulled over for speeding. Then it's all legal to go in the car and find the cocaine. But in this case, the officer makes a mistake. So going forward quickly, as far as folks in this situation, not that we're all carrying drugs around in our car, but extend it to something, more, relatable, I guess.
Well, the problem for people is that, and again, what Justice Sotomayor says is that these stops can be annoying, they can be frightening, and they can be humiliating. And the problem is that people will have one more reason that they can be stopped, one more excuse for the officer to use to stop them, and that's something that bothers some people.
Corey Rosensteel with his insight here on this Wednesday. Appreciate the